This video explains the types of motions you can bring in family law. Because it can take a long time to get a final court order, a motion lets you ask a judge for a temporary order to deal with specific issues, usually before trial or without a trial. For example, you might need a temporary order for child or spousal support, or you might need a temporary order about where your child will live so you can find a school for them. There are several different types of motions, including consent motions, regular motions, urgent motions, and procedural motions. There's also a motion to change, which is used to change a final court order or agreement. The type of motion you bring usually depends on whether you and your partner agree on the order, what you're asking for, and how urgently you need the order. It also depends on where you are in the court process, if you have a previous court order or agreement, and which court is dealing with your case. If you and your partner agree on some or all of the issues in your case, you can bring a consent motion at any time. This lets you ask the judge to turn your agreement into an order. You and your partner decide if you want the order to be temporary or final. If you need a temporary order quickly but not urgently, you bring a regular motion. Regular motions can happen only after there's a case conference. A case conference is when you and your partner speak with a judge or dispute resolution officer about how to move your case forward and solve your issues. If you have not had a case conference, ask the court how soon you can schedule one. This will help you decide if you can wait to bring a regular motion. Check the court's website for the practice directions or rules about scheduling motions that apply to your local court. Contact the court if you need more help. Usually, a regular motion is with notice to your partner. This means your partner is told about the motion and has a chance to respond before the hearing. In very few situations, a regular motion can be without notice to your partner. For example, this could happen if there's an immediate risk that your partner will seriously harm you or your children, or giving notice could have serious consequences. If you need a temporary order quickly and urgently, you bring an urgent motion. You can bring an urgent motion at any time during your court case, even before you start a court case or have a case conference. Most urgent motions are also with notice to your partner. For example, you might bring an urgent motion with notice if your partner does something that goes against your parenting agreement, like stopping you from seeing your children, or your partner may have agreed to sell your family home, but now they're acting in a way that prevents it from being sold. There are very few situations where you can bring an urgent motion without notice. For example, you might do this if you have a good reason to believe that your partner is going to take your children out of Canada without your permission. Or you may believe that your partner is going to move money out of Canada so you cannot access it. An urgent motion without notice is also called an emergency motion or ex parte motion. Court orders that are based on a motion without notice usually last for a short time. Then, there is another hearing where your partner can respond. Procedural motions are about the court process or timetables. You can bring a procedural motion at any time, and it can be with or without notice to your partner. For example, say you need more time to complete your court documents, and your partner won't agree to this. You might bring a procedural motion with notice. Your motion would explain why you need more time. Or maybe you want to start a case, but don't yet have a document the rules say you need. You might bring a procedural motion without notice since the case hasn't started yet. Your motion would explain why you do not have the document and ask the court for permission to start your case without it. If you want to change a final court order that's about parenting or support, you usually have to bring a motion to change. If the order is about child support, you must show that something has changed that is related to the child support table or your child's expenses, such as daycare costs. If the order is about spousal support, decision-making responsibility, or parenting time, you must show that there's been what the law calls a material change in circumstances. This means that your situation has changed so much that your earlier court order needs to be changed. There are other types of motions you can bring if your partner is not following a court order or the court rules. For example, you might bring an enforcement motion asking for your partner to pay your legal costs, or a contempt motion asking that your partner go to jail. Use Cleo's guided pathways to fill out your court forms. To learn more about motions and family law, go to stepstojustice.ca/motions.